You might be wondering, Mikayla, I'm not a lawyer and I don't plan on breaking the law, so why do I need to know what a deposition is? If you ever get injured in a car accident, if you ever get divorced and there's a dispute over custody or money, if you ever witness a crime being committed, there's a high likelihood that you'll have your deposition taken. And you should definitely know the meaning of the word deposition along with several other legal terms that I'm going to teach you in this video. Hey guys, my name is Mikayla and I'm a lawyer who happens to have a YouTube channel and enjoys the general public being informed about the legal situations they may one day find themselves in. So in this video, I'll be going over 10 general legal terms that every single person should know regardless of who you are and what situations you may experience at some point in your life. And if you haven't seen my previous video on some of the more basic legal terms you need to know, don't forget to watch that to have a good foundation before we build upon some of those terms in this video. And with that, let's get into some more general legal terms. Discovery. Discovery is a very important and critical component of the litigation process. After a lawsuit is initiated, the parties on both sides of the case spend months and sometimes even years exchanging and requesting factual information, documents, and other evidence that can be useful in pursuit of the case. Discovery is just the gathering of information, and if done correctly, it helps to set your case up for success should it ever go to trial. Deposition. A deposition is a procedure that takes place during the discovery process. It's when a witness to an event provides testimony under oath that is memorialized by a court reporter and done without judicial oversight. It's basically a question and answer session that takes place outside of the courtroom and with lawyers from both sides as well as a court reporter present. But with the deposition comes a ton of rules that the lawyers must follow. And if those rules are broken, the validity of the deposition can be called into question and brought before a judge. If you ever end up needing to get your deposition taken, or being deposed as we call it, you'll likely meet with your lawyer beforehand during what's called a pre-deposition conference. And during that, they'll go over all of the nitty-gritty rules that you'll need to follow during your deposition. If you're not a party to a case and you're instead just a witness and you don't have a lawyer, totally fine. Whoever's deposing you may still want to speak with you beforehand or not. It's all dependent on the situation, but regardless, depositions are a very helpful tool that allows the parties to gain information about the case at hand. Appeal. Judges make mistakes, as we've all seen before, and sometimes those mistakes result in an issue in the case or the entire case as a whole being decided incorrectly or unfairly. That is when the appellate court comes into play. To appeal a decision in a case means to apply to a higher court in an attempt to reverse said decision. In the legal system, there are different courts at different levels, some higher than others. Appellate courts are higher than circuit courts, and circuit courts are higher than county courts, for example. And to appeal a decision to a higher court, several requirements must be met. But for the purposes of this video, just know that an appeal is basically asking a higher court to review the decision of a lower court that you believe was decided incorrectly. Admissible versus inadmissible. Admissible just means allowed or permitted. Admissible evidence is evidence that is allowed to be utilized in court. Inadmissible, you guessed it, means it is not allowed to be used. So that confession that the cops obtained illegally, that is going to be inadmissible in court, but that's another video. Speaking of other videos, if you are enjoying this one, I'll be releasing 2 more just like it later on this month, one with civil terms and one with criminal terms. So be sure to subscribe so you don't miss out. Mediation. Some cases never end up making it to trial because they resolve before the trial is even set to begin. And some cases even get resolved before a formal lawsuit is actually initiated. And for that, we owe a big thank you to the mediation process. A mediation is a form of alternative dispute resolution, or ADR for short, where all parties in a case come together and negotiate their wants with the help of a mediator. The mediator is basically a moderator. They are an unbiased third party with no stake in the case whatsoever. And their role is to help all of the parties in a case come to a mutual agreement that will make the case go away. Mediations often start with all parties presenting their version of the facts of the case. They then all split into separate rooms and the mediator bounces back and forth between all the rooms, trying to find some middle ground where all parties will walk away feeling satisfied. The mediator can cannot force a party to agree to anything, and oftentimes the mediation ends up being unsuccessful because the parties just couldn't come to a mutual resolution. But you may be surprised to know that 80 to 90% of cases resolve before trial through mediation or some other form of ADR. So it's an incredibly useful tool and process to have. Arbitration. Arbitration is another form of ADR, but it differs from mediation in a few ways. It's more formal than mediation, but less formal than an actual trial where there are endless rules that have to be followed. Remember how I said a mediator cannot force the parties into an agreement? Well, an arbitrator's say is final. Like in a mediation, all sides present their case to the arbitrator, who likewise is a neutral third party. But this time, after learning the facts of the case, the arbitrator makes a final decision as to what will happen with the case. And that decision, with very, 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 very few exceptions, is not appealable. I personally like to think of arbitrators as mini judges. They're not presiding over a case in a trial like a judge would, but what they say is final. They're basically like the judge and the jury. A lot of power there. Probate. You should have a will. Everybody that owns literally anything, especially people with kids, needs to have a will. I'll be making an entire video later on this year about why wills are so incredibly important for literally everyone. But for now, just know, if you don't have a will, please make a will. Probate is the legal procedure by which a deceased person's assets are distributed. If you have a will, the probate court administers your assets in accordance with your will. And if you don't have a will, you die intestate. Bonus term, you don't want to die intestate, because if you do, you know what will happen to your assets, your money, your belongings? The state does. The government. The entities that you definitely do not want making those decisions for you. For the sake of yourself and everyone who loves you, have a will. It will make the probate process a lot easier. At-will employment. Did you know that in 49 out of 50 states, you can be fired from your job for literally no reason? That, my friends, is called at-will employment. I'm not joking. As long as the reason is not discriminatory, your employer can fire you for any reason or no reason at all, even if you haven't done anything wrong. If you wore a purple shirt to work one day and your boss doesn't like the color purple, they can fire you for that. If your boss is a big Celtics fan and they find out you like the Lakers, they can fire you for that. If your boss literally just woke up on the wrong side of the bed and wants to go on a power trip, they can fire you. The only state that differs from the other 49 in this way is, randomly enough, Montana. In Montana, at-will employment only applies during your first 6-month probationary period, or whatever probationary period that company has set. After that probationary period, employers must document good cause to fire their employees. Anywhere else though, it's fair game, which is kind of crazy when you think about it. I never thought I'd say this, but maybe we should all try to be a little bit more like Montana. Pro se. Pro se means representing oneself without a lawyer, and it's something you should pretty much never do. There's a reason that lawyers must go through 7 years of schooling before they're able to step in a courtroom and represent their client's interests in front of a judge. So trust me when I say, if you're thinking about just skipping over the whole lawyer thing and think it's a good idea to go fight whatever cause you're trying to fight by yourself, it's not. It's just not. Again, video on this coming soon, but just get a lawyer. Promissory note. Did you know that you, as in you watching this video, can draft a legally binding contract if you loan someone money and want to have a legal tool to enforce that loan should they try to not pay you back? That's right, it's called a promissory note, and to have an enforceable promissory note, it must meet 6 requirements. It must contain 1, the date of the loan, 2, the amount of the loan, 3, the names of both parties to the loan, 4, the rate of interest, 5, whether there's any collateral involved, and 6, a timeline as to when that money should be paid back. I can make a whole video on promissory notes if you guys would like, just let me know. But in the meantime, I just thought it was important for everyone watching this video to know that you have a tool at your disposal if you're ever worried someone's not going to come through on what they owe. And that's it for today's video. I hope you guys liked it and learned something new. And like I mentioned earlier, I will be dropping a civil term version and a criminal term version of this video later on this month. So subscribe, stick around, and before you guys head out, be sure to click on the video on the screen right now where I did a prosecutor versus personal injury lawyer speed dating, where you can learn a little bit more about the types of lawyers we'll talk about in videos later this month. Thanks so much for watching, and I'll see you guys in my next video. Goodbye and go thrive.